If you're a fiduciary tasked with selling a probate property or conservatorship under limited authority, you know how overwhelming the process can be. Between court approval, conservatorship rules, and managing heir and beneficiary expectations, it's easy to feel stuck. That's where I can help. In this video, I'll break down exactly how court-confirmed property sales work step by step. With over 21 years of experience and more than 900 Bay Area real property sales under my belt, I'll show you how to navigate this process efficiently and minimize liability while achieving the best outcome for everyone involved. Let's get started. So the first question that comes up is, why do I have to go through the court confirmation process? Limited authority probate sales require court confirmation because the executor, administrator, or conservator does not have the authority to act independently. The probate court oversees the process to ensure the property is marketed and bought or sold for the highest price possible. This is usually when someone dies without a will, which we call intestate, or someone is conserved and a conservator is acting on their behalf. Most conservatorship sales in California require court confirmation. The first step in the process is similar to other real estate sales in that the estate's legal representative interviews qualified real estate agents. But unlike other real estate sales, choosing an experienced probate real estate broker is of the utmost importance, as a mistake in the probate process could send you down the wrong legal path and could prove costly, both in time, legal fees, and ultimately the sales price. We have a great video in our channel about how to choose the best experienced probate real estate broker. The next step in the process is determining the value of the property and the suggested list price and enter into a listing agreement to sell the property with a qualified broker. Note that as part of the process with your attorney, an independent probate referee chosen by the court will also conduct a court appraisal. Note that the final selling price must be within 90% of the appraised value set by the probate referee. But if there is a difference after the property is marketed, the referee can adjust the value if necessary. And in most cases with limited authority and conservatorships, you and your attorney will need to petition the court for the authority to list and sell the property. As part of the petition, the attorney will submit the real estate broker's listing agreement for review by the court to ensure it complies with state and local probate code and rules. Once the listing agreement is approved and signed, the property preparation and marketing can commence, but there are additional legal requirements to be met. First, the attorney for the estate needs to publish a notice of sale a minimum of 3 times at least 10 days ahead of the sale. The third notice should come 5 days following the first one. Second, any interested party submitting an offer on probate property is required in most instances by California to make a 10% earnest money deposit with their offer, which is higher than the standard 3% as is custom in most non-probate sales. The estate's representative can either counter or accept that offer. All offers subject to court confirmation must be contingent on confirmation by the court, with specific language in the contract to that effect. Despite the seller accepting the buyer's proposal, the agreement is not final until confirmed by the court. Within 30 days of accepting an offer, the probate attorney must petition the court for the confirmation hearing. The court date is usually set 30 to 60 days out by the court in the county hearing the probate. Before the confirmation hearing takes place, the estate's representative must inform specific parties with interest in the sale, heirs, other attorneys, and other interested parties in writing about the sale terms and the hearing date. This is called a notice of proposed action. Should those parties have any objections to the sale, they can file those in writing with the court in advance of the hearing. At the court confirmation hearing, the court invites all potential buyers and other concerned parties to attend. If there are no objections to the sale at the hearing, the presiding judge will move to the confirmation portion of the hearing and ask if there's anyone in the court that would like to overbid on the property over the accepted buyer's offer. Those accepted buyers are often in court as well. In the event there is an overbidder in court, the first overbid price to start the bidding is set by the court at 5% plus 500 over the accepted offer. All bidders in court must be 100% non-contingent, meaning they are purchasing the property as is with no contingencies and all cash at close. At that point, the property is sold auction style to the highest bidder in court. If no overbidders show up for the auction, the buyer with the first accepted offer will generally be confirmed to be able to purchase the property for their initial accepted offer price. Roughly a week after the court confirmation hearing, the court will issue an order confirming the sale at the agreed upon terms, and then escrow can close. So as you can see, this is a sophisticated process that is not for inexperienced realtors and is full of potential pitfalls for the fiduciary and their attorney. With over 300 court-confirmed sales in all major Bay Area counties and courts over the last 21 years, I can assist you with all that is needed for a top dollar sale that limits your stress and time, reduces attorney fees, and limits your liability. Look forward to seeing you on the next video.